Okay, I was having a little trouble getting it on live stream, so it's coming up now. All right, good morning. This is the jail calendar for courtroom 304. I'm going to call the calendar. If the person is represented, then I hope their attorney will speak up on their behalf. If they're not represented, then when the attorneys go into the breakout room to speak with the jail, they can request of those individuals who are not represented, whether they want to represent themselves or whether they need counsel. The first person on the list is Ariana Kashmir Danner. I believe Ms. Danner was a reset from a previous calendar.
Yes, Your Honor. Ms. Danner has a pending probation revocation. We had hoped to resolve the probation revocation and her new case together. I've been trying to reach out to probation, but I haven't received any paperwork on Ms. Danner or Garcia. I don't know if their probation is in a higher court or not being handled by this probation office.
Mr. Austin, do you have anything on Danner and Garcia?
No, Your Honor. We are not showing a Danner on probation with us here in state court.
Is it possible that she has probation in another jurisdiction?
Judge Hayward.
Yes, ma'am.
Good morning. This defendant actually had a VOP in the Riverdale Municipal actually in jail on that. But they are OTB since September, which was yesterday.
I'm sorry, the last part cut out. What did you say again?
I apologize. The defendant is OTB on September 12th, which was.
Okay, so she's OTB from us and the VOP is from Riverdale.
Yes, Riverdale Municipal Court.
Okay. All right. Then she'll go on an arraignment calendar. We'll just reset that. Okay. How about Vanessa Garcia? Miss Melissa.
Yes, Judge. That defendant has probation, but with the court.
But with what? I'm sorry. It keeps cutting out at the end. Miss Melissa, it's not you. It's the internet we have here at the courthouse.
Clayton County Superior Court. They have probation with them. Yes, Judge.
Do you happen to have the date of her probation revocation in that matter, Ms. Melissa?
I don't have access to their documents, so I'm not able to see any of that.
Okay. All right. I will just need to have a conference with Ms. Garcia. Yeah.
That's one of the dudes that run. Walter.
All right. All right. We have a petition on Cesay Guzman.
I'll need a conference with that client as well as the assistance of the interpreter.
I'm present here.
Thanks, Ms. Sonia. How are you?
Good morning, Yona. I'm doing good. Thank you. And you?
Good morning. I'm doing great.
Good.
Dietrich Donald De La Harris.
I just need a conference with the state on that matter.
Satarius Darnell Holt.
Your Honor, that's a stipulate and agree to the technical violations.
And Jama Vasir King.
Your Honor, that's a no pros to count 1 and no low to count 2.
Jamie Lee Moreno,
Your Honor, I'll need a conference. I attempted jail visits a couple of times and Moreno did not show up.
DeMontavious Snyder,
Your Honor, I've discussed this case with Snyder and he was just going to let me know today what he wants to do. So I'll need a conference.
it's a petition for revocation,
That's
correct?
right. That's right.
All right. And Almarquise Dewan Williams.
Your Honor, attempted jail visits a couple of times. Williams did not show up for the jail visit, so I'll need a conference.
All right, so I'm going to set up the breakout room. I'm going to add Miss Sonia. If you all would be so kind as to make sure that the individuals who need interpretation are handled as quickly as we can, so we can, I may have to share Miss Sonia, as much as I hate to.
You're trying to steal me away to another Zoom. I said, no.
See, I knew somebody was lurking out there.
10 o'clock, Judge Hayward, you are 1 hour behind. You have to wait now.
Right.
Judge,
Yes, ma'am.
Did you want to call the bond modification calendar or what?
Yes, ma'am. Let me pull it up on my tablet. All right, so for bond motions, these were filed downstairs, I believe in the magistrate court, but these are all cases that are bound up to us or should be bound up to us. Natalie Ornelas, Crystal French, Keontae Hernandez, Curtis Williams, Zachariah Williams, Patricia Tatum, Charles Lawson, Terrell Everett, and Kiernan Jones. So it is my understanding that these are all Lister and Holt bond motions, but I could be wrong.
Yes, Your Honor, just to perfect the record a bit, the cases are still open in magistrate court, so none of them have been bound over to state court yet. I do know that Natalie Ornelas was received into the solicitor's office yesterday.
Okay.
Patricia Tatum was also received into the solicitor's office yesterday, which means that because they're jail cases, they'll be accused today.
Okay.
And going to a jail calendar today. The remainder of them, I do have certain notes about each individual, and we can address each one as the court calls them.
Okay, so it's my understanding as presiding judge for the month of September that these cases aren't heard anymore in magistrate court. They come up to the court that they're supposed to come to, and they give the judge, the presiding judge, the opportunity to determine whether the bonds are be modified from whatever was said at first appearance. So as September's presiding judge, I'll make considerations as necessary. So we'll go ahead and talk about those while you're in the jail. If you want to talk to those individuals and see if there's anything that you need to bring forth with respect to the motion to modify bond, then go ahead and let me know that. But at this time, I'm going to go ahead and set up the breakout rooms.
Thank you. And I've conferenced with almost everybody but one, I believe.
Okay.
And so I'll be able to kind of get announcements on those quickly. Mr. Brooks, thanks for the information about the bind overs. That is helpful. And just to.
Well, if I can put Mr. Kamani and Mr. Taylor in the breakout room with Miss Sonia and let them talk to the individuals in the jail, then I can deal on the motions calendar with you, Mr. Moore, and we can at least get started on that. How's that?
Thank you.
All right. All right. So I have the jail, the Miss Sonia, Mr. Kamani and Mr. Taylor are all going to be in breakout room number 1. Invitations are open. All right. Let's see. All right, so Mr. Moore, I have a list and then I just have them set out I have the bond motions before me. So is there someone you want to start with?
Your Honor, it doesn't really matter except for Charles Lawson. I've not been able to meet or speak with him. I suspect that's because he has some difficulties. I was going to give it a shot if he were there here in a moment. Natalie Ornelas, I had spoken with her, but my understanding, I believe her mother was going to join the meeting because she had some additional information. I was just going to try to speak with her if she was here. But everybody else, I think, is ripe to address in some form or fashion.
Okay.
So,
well, since this is the first one that comes up, let's talk about Kieran Jones.
All right.
Kieran Jones, I'm sorry.
Yes, ma'am. If I might, let me just pull out his information.
Okay, and for the record, this is State of Georgia versus Kieran Jones, 2022 WA 08544. Charge is simple assault.
Yes, ma'am. And if you'd like, I'll go ahead and give the court some information about his situation.
Okay, and then Mr. Brooks can respond.
Thank you. Your Honor, Kieran Jones, actually, his case has been pending for some time. He was down in the magistrate court, I think back in, well, here I have it right here. Back in May 23rd is the day that he was arrested, and his charge is a simple assault. I've spoken with him a couple of times. I think one of the issues might be that they have his name messed up in the magistrate court. I think they have it reversed. I don't know. I mean, I know they have a lot of trouble down there generally, but that might be giving them trouble as far as finding the information and binding it over. At this point, given the length of time that he's actually been in custody, being what was it, almost 4 months, on a simple assault charge, we're requesting unsecured judicial release. I did want to let the court know that he does have a residence. He's got an address. My understanding is he's able to return there. He was employed prior to being arrested. We talked about that a little bit. I think he's not certain, but I think he is optimistic and he thinks he might be able to still have that job. He was working there for about 6 months before his arrest. I don't believe that he has any felony convictions. He had some issue out of Illinois that was very old, 20 years ago, but I don't think it was a felony conviction. He had some sort of misdemeanor, I think, a couple of years back out of a different county. But aside from those issues, my understanding is that he doesn't really have any significant criminal history. I would ask the court for an unsecured judicial release. Given all those circumstances, I think now it's appropriate, especially since, you know, with each one of these, after I met with them, I think what's going on is at first appearance, most of these clients actually waive, but then for whatever reason, I mean, they waive right there at first appearance, and for whatever reason, the paperwork kind of goes away. So for each one of these, I file a waiver as soon as I speak with them to try to move it along before we get into court. I guess that was maybe effective for a couple of people on this calendar. But we tried that again, still to no avail for Mr. Jones. And so I'm really kind of at a loss what to do except for to ask the court to release him. Also for, and I'll just say this generally while we're speaking about Mr. Jones, for anybody on this calendar that we're discussing, maybe the courts doesn't find it appropriate to give a release at this time, I would submit that the court would have the power to order that the case be bound over under the statute. You know, certainly magistrate court can sit as a court of inquiry as to whether or not there's probable cause in the case. And under the statute, I know the state court also has similar powers. I know it certainly wouldn't be the normal procedure. However, I've seen other judges do it, you know, when in extreme circumstances when nothing's happening, just go ahead and bind the case over by your order as opposed to that of the magistrate court. And I'm not, I guess I would ask that for anyone who's kind of been languishing in the alternative for the unsecured judicial release that we are requesting. Thank you, I appreciate it.
No problem. Mr. Brooks?
Mr. Jones presently has a bond for simple assault in the amount of $2,500. I understand he was arrested on 5/23/2022. The state does have concerns with the nature of the charge. The allegation is that he branched a firearm during a verbal altercation with people who he resided with. He alleged that the firearm was held by his side, but the folks who he were with reported that they were in fear of being shot and receiving violent injury. I don't see any history of felony convictions, but he does have several misdemeanor convictions in Georgia and Illinois. There was an entering auto out of Chicago. I'm not sure if they treat that as a felony or a, it was treated as a felony out of Cook County, and that was adjudicated as I think he may have been a delinquent at the time. I'm not sure. I'm not sure if he was treated as a juvenile during the course of that, but he does have felony history out of Chicago. This case, the challenge and to Mr. Moore's request of the court at the latter part of his argument, the challenge is not necessarily the order that it be bind over. It's the actual movement of the paperwork. And so the court, we can directly accuse it, but we will be directly accusing it on copies of what we have in the actual original documentation with the original documentation with the judge's signature is what's not finding its way to us. We're just moving it on copies of unsigned documentation just to move it along because the person's in custody. Now, given that he's been in custody for so long, 5/23, the state won't raise any significant fuss about about his release, but rather than do an OR, we would ask that there be a bond reduction as opposed to an OR. We do have concerns with the nature of charge. As a condition, if he is released on bond, he should forfeit all weapons. He's not possessing any weapon. He's not to return to the incident location. We have that location as 6126 Navajo Trail, Morrow, Georgia 30260. And that would be the conditions that we will request of court if he's given a bond reduction or a bond. Now, it's my understanding that the jail generally has been giving OR bonds on nonviolent offenses for misdemeanor offenses throughout the pandemic to ensure that there's space for felony folks.
I've been given OR bonds throughout the pandemic for nonviolent offenses. Generally, anybody with a traffic offense or something like that, if a bond order comes before me, they're getting an OR bond because I just, Mr. Brooks, Mr. Moore, my training and education in the law tells me that this is pretrial detention, and none of the people that we hold in this jail, unless they're here for reconsideration of a case, none of these people are convicted of the offense for which they're in jail. And so I look at him being in jail since May and it is now September, and I know that there's almost no possible way that he would have gotten that amount of time under any sentence that I could contemplate unless I'm missing something. So at this time, the court is going to order an unsecured judicial release for Mr. Kieran Jones, case 2022 WA 08544. His conditions will be that he will have no contact with any named alleged victims in the incident, no weapons of any kind, no knives, no guns, and he will not go back to the incident location.
Your Honor, I don't know how best to request this, but just to ensure that there's a proper address on file for him so that future notices reach him. Can we put that on the record?
Right. The defendant will be released upon providing to the sheriff's office authorities an address for which he can receive mail. It doesn't necessarily have to be where he lives, but for which he can reliably receive mail.
Thank you, Your Honor. I will create that and present that to you and Mr. Brooks as soon as we're finished.
Okay. All right. Next is.
Do we want to take Ms. Sonia, Judge, since they're back?
Oh, I'm sorry, Miss Sonia. Mr. Taylor, is your case for Miss Sonia ready?
Yes, Your Honor. Mr. Guzman will be admitting to the stipulating to the technical violations.
All right. One moment.
Accepting the recommendation of 60 days in termination.
Señor Guzmán, su abogado está diciendo que usted va a admitir las violaciones de las condiciones de probatoria y va a aceptar la recomendación que le dieron de 60 días y cerrar el caso.
All right. This is the probation revocation hearing.
Esta es la audiencia de revocación de probatoria.
For Cesar Guzman,
Del señor Cesar Guzmán,
aka Florentino Guzman Fuentes.
también conocido como Florentino Guzmán Fuentes.
Mr. Guzman was here before this court on case 2022 CR 00720.
El señor Guzmán está aquí presente respondiendo a su causa 2022 CR 00720.
Mr. Guzman was before the court for theft by taking on June 9th of 2022.
Usted estuvo presente frente a la juez el 9 de junio del 2022 por robo de propiedad.
He was convicted and given 12, he entered a plea and was given 12 months on probation. He has 7 months and 11 days remaining.
Usted fue sentenciado a 12 meses de probatoria, aún le quedan 7 meses y 11 días de esa probatoria.
It is alleged that he has committed the new offense of theft by shoplifting on August 8th of 2022.
Ahora usted tiene otro cargo nuevo en su contra por robo de tiendas el 8 de agosto.
He failed to report on July 15, July 25, July 27th, and he last reported on July 22nd by phone.
Y tampoco se presentó a su oficial de probatoria los días 15, 25 y 27 de julio. La última vez que habló con su oficial de probatoria fue el 22 de julio y lo hizo por teléfono.
He failed to complete 40 hours of community service.
No hizo las 40 horas de servicio comunitario.
And he failed to pay his $200 in arrears.
Y tampoco pagó lo que debía, que eran unos $200.
Mr. Austin, what's the recommendation?
Your Honor, the recommendation is 60 days to serve and close case.
Mr.
La
Sorry.
recomendación del oficial de probatoria es 60 días de cárcel y luego se cierra el caso.
Mr. Taylor, on behalf of your client.
Nothing further, Your Honor.
Su abogado no
And-
tiene más nada que decir.
Or rather, we would just ask that he be credited for the time of lockup, or since the time of lockup.
Vamos a solicitar,
Understanding. Go ahead, Mr. Sonia. I'm
oh, sorry. Voy a solicitar que cuenten todos los días que el señor Guzmán ya lleva preso.
Okay, and you all are stipulating to the technicals only?
Yes, Your Honor.
Solamente estipulamos o aceptamos las violaciones técnicas de la libertad condicional.
All right, the court is going to accept the stipulation, and I'll accept that Mr. Guzman is stipulating to the technicals only, which will preserve his right to defend himself against the new charges.
Entonces voy a aceptar la admisión y solamente las estipulaciones, o sea, así él podría defenderse del nuevo caso que tiene.
Mr. Guzman, I'm going to revoke 60 days of your probation.
Señor Guzmán, entonces voy a revocar 60 días de su libertad condicional
Upon service of 60 days, including the time that you have served since arrest.
se cuentan desde el día que usted fue encarcelado, esos 60 días.
After that service, I'll close your case.
Así que una vez que cumpla o termine los 60 días, se cierra este caso.
All right. Anything else on behalf of this gentleman?
¿Algo más?
Nothing further, Your Honor.
Nothing
No,
from
señor.
probation, Your Honor.
All right, so I'm gonna do the form and I'll go ahead and send it over.
Thank
Voy
you,
a
Your Honor.
completar el documento y lo mando.
Mr. Taylor, did you have any other clients in the pipeline that you needed to speak to with Ms. Sonia?
No one else. I don't need I don't need Miss Sonia anymore.
All right, Ms. Sonia, you are free to go and help some other judge.
Thank you, everybody. Bye-bye.
Bye-bye. Have a great day.
You too.
All right. All right. So, Mr. Taylor, Mr. Guzman, you can go back with the sheriff's office. Once you serve your 60 days, you'll be released. All right. Mr. Taylor, did you need to go back into the breakout room?
Not with the jail at this time. I do need to break out with Mr. Brooks if he's available.
Your Honor, I need a breakout room with the jail.
Kamani. All right, the jail and Mr. Kamani can go back into breakout room number 1. Mr. Taylor, I'll put you in breakout room number 2 with Mr. Brooks. And then we come back, we'll finish, we'll continue with the motions calendar. Okay.
Your Honor, while we're waiting on everyone else, is it okay if I sound for Miss Ornella's mother, and if she's here, maybe I could get in a breakout room with her?
Sure.
Is anyone present on the call for Miss Natalie Ornelas? Oh, okay. Maybe I'll try to give her a call while we're on. Thank you, Your Honor.
Okay, no problem.
Deputy,
Yeah,
can we just go back to the breakout room? I haven't finished speaking to everyone.
okay.
Yes, Mr. Taylor?
Yes, Your Honor. Could you send me to the jail
Yes.
room?
All right, put you back in breakout room number 1.
Thank you.
Any news, Mr. Moore?
I'm sorry, Your Honor, I didn't know.
No, that's okay. I was just asking if you had any news, but we can go on with Mr. Terrell Everett's case.
Yes, ma'am. Thank you.
I have him down as
Eddie Walter.
Eddie Walter.
That's his AKA.
Huh.
Or at least that's what I have on here.
Yes.
So we'll see if it was one of those LE number mix-ups. All right, Mr. Terrell Everett, AKA Eddie Walter. He's on the calendar downstairs for 2022 CW 52308 for battery, 2022 CW 52309 for criminal trespass, and CW 52310, I'm sorry, for obstruction. Mr. Moore?
Thank you, Your Honor. Yes, I think that the name issue may again be the problem with his case not moving along. Again, similarly to other clients, after making contact, I attempted to file a waiver to get the case bound over and have had no response on that. His name, I believe, on those warrants, I believe, is Eddie Walter. I think he's in the jail as Terrell Everett, and I have his file open as Terrell Everett. Regardless, Your Honor, the primary reason why we are before the court is simply because he's been in custody since May 18th on this case with no movement from the magistrate court. He does have an address, a stable address to which he can return. Discuss several things that he's got going on in his life, including his job. He is a construction worker. I think he's a general laborer. He's been doing that for some time. He's actually got close ties to the community, plenty of family around. So I think if the court is inclined to provide him with an unsecured judicial release, he has those things in place that can give the court some confidence that he will return and address this issue at the appropriate time. I certainly do appreciate the state's willingness to reduce bond. Unfortunately, for all of the clients that we're discussing here today, they simply don't have the financial means or wherewithal to make any bond, I don't believe, or else they certainly would have attempted to up to this point. So for Mr. Terrell Everett, I believe I understand the nature of the charges. The state might have some concerns about his behavior. However, again, I think the circumstances certainly are as such that he's served a lengthy jail term, and that might be all the sentence that he would receive, possibly, if and when he came to court. So the court should have some confidence that he understands that and that he knows he'll be facing likely not much of a jail penalty when and if he returns. And I believe that's one of the primary focuses of the court's inquiry, is whether or not he will be able to return to court at the appropriate time. And I believe he has those things in place that will allow for that. So given everything involved in this case, Your Honor, we would be requesting that he be granted an unsecured judicial release. Thank you.
Mr. Brooks?
Mr. Everett, the allegation before the court about Mr. Everett is that he was at the airport and went behind a Delta Dash office, pulled out his penis and began masturbating. He grabbed one of the female employees by the shoulder, and she ultimately pushed him away. And another employee restrained him.
Did he work at the airport, or was he transient?
It's not clear in the warrants, and that's all I do have. I don't have an incident report. I'm just looking at the probable cause affidavit. So we do have some significant concerns about this case. As I look at his local history, though, I do see that he had a prior public indecent exposure charge from April the 30th of this year that was ultimately dismissed, as well as a disorderly conduct. I don't know what behavior led to that, but I do know what public indecent exposure means. And so this seems to be a recurring behavior. I do reviewing his criminal history, GCIC as well. He does appear to have a significant criminal history with about 34 cycles to include several felony convictions. He's been in custody since May the 18th. I don't know, looking at his the entirety of the fact, I don't know that he has a stable address, and I do have concerns that he will return to the airport and that he doesn't have anywhere else to go. And so I don't know what's the best outcome, but I'll defer to the wisdom of the court and with this knowledge.
Mr. Moore?
Your Honor, the only thing that I would say, I was not privy to the facts of the case as of yet, as we haven't received that from the magistrate court. However, as far as the address goes, he did give me an address, which he says that's the place he lives. It does correspond to a house. I haven't verified that. I just took it at face value. It seems plausible that he does live there. I just don't have any verification for that. As far as his employment goes, I don't believe he's an employee of Delta. That's not what we discussed. We discussed the work that he does with construction. So I can't really speak to his presence at the airport. But again, I just, as far as the background goes, he discusses with the significant ties to the community and the location at which he will be residing. And so that's the information I conveyed to the court. And for our part, Your Honor, I acknowledge the criminal history. However, again, being in jail for 120 days and just languishing, I don't know what else to do to try to get his case moving along, other than to have him released until they can figure it out somehow. And so that's still our request. Thank you.
All right. I'm willing to release him with the understanding that he will not go back to the jail, to the airport for any reason.
Your Honor, can the state make a request of the court as to a condition?
Yes.
We would request that he gets a psychosexual evaluation.
Yeah, I was gonna say that. The only problem, Mr. Brooks, is always how do I monitor that? Especially for someone who has limited resources. So, if I say that and he's out of jail on his own and he didn't have enough money to make bond in the jail, then I'm not sure what I will order it. I can, but I'm not sure what his resources are, what the availability of those services are that he could access in the situation he currently finds himself.
Yes, ma'am.
So if
I would rather the court not order it if that is a concern, because it would just lead to an unnecessary motion to revoke bond if he doesn't do it.
Right. And I just don't trust that. I feel like there's something there. And that was my thought process, except then I go to the, how's he going to get the services? And this is not a service rich area that we find ourselves in, unfortunately.
Yes.
So, but I will require him to stay away from the alleged victim in this case, to stay away from the airport. Absolutely. If he got to travel, then he's going to have to go through Birmingham or take the bus. I just know. And so that those conditions and any others that were set at first appearance.
Your Honor, no problem. I'll put that in there. With regard to any case in which there is a victim, I don't have the specific information to put into the order.
Okay, well then he's not to go back to the airport.
Well, I was going to ask, would you like me to generally put no contact?
Well, is it possible, like assuming these people have been first appeared, because if they haven't, they all need to be released. But if there's a bond condition from first appearance, do you have access to that?
It just has, the bond order just has do not return to the airport.
Yeah, so same thing.
Okay, gotcha.
All right.
Thank you.
All right, let's see what the next one is. Charles Lawson. Are we ready to talk about Mr. Lawson?
Your Honor, he's not. That's a gentleman I was unable to meet with. I've got some history on him. I think he has some serious mental deficits that I need to check out. So we may not be asking for his release. I just need to visit
Okay.
him, please.
All right. So I know Patricia Tatum is coming up to be accused. She should be on next week's calendar, possibly.
Yes, ma'am. Whichever courtroom she in, she'll be on the next jail calendar.
Okay.
I can tell you which courtroom she'll be in. Give me just one moment.
That's all right. It may not be mine. That's fine.
All right.
Zechariah Williams.
If I could, let me just pull up his information.
Okay, so I have Mr. Williams before the court on 2022 CW 52998 for criminal trespass. And then I have a bunch of WAs, 2022 WA 11559 for simple battery, 11560 for obstruction, 11561 for VGCSA, 11562 for tag transfer violation, 11563 no insurance, 11564 seatbelt violation, 11565 stopping on the roadway, and 11566 expired tag. I'm just telling y'all, when I was in magistrate court doing warrants, this is what we call he made the police officer mad.
Yes, ma'am.
Anytime you see 11 traffic warrants, I mean, come on.
He was not arrested for the charge that was initially on the warrant, or excuse me, on the motion, that criminal trespass that was executed when he got arrested for these traffic offenses. And so the incident date on that criminal trespass is 6/28/22, but he was not arrested until the traffic offenses, which was 7/22, about a month later.
Okay. All right, anything for Mr. Zechariah?
Yes, ma'am. Thank you. Yes, Mr. Brooks is correct. That was, he gets stopped and then the guy's got the warrant and then everything proceeds from there. There certainly are several warrants here. I'm not sure if that's leading to some difficulty in the magistrate court. But regardless, again, not quite as bad as the previous two clients that we discussed, but he has still been in custody for some time. My understanding of his history, I don't believe that he has any significant criminal history. I know he's in Louisiana for a time, but I don't believe he has any convictions. He does have family. He does have connections to the community, support system, mom, dads, sisters, brother, nephews. He's been actually doing pretty well for himself, work-wise. My understanding is he's got a carpet cleaning business and a pressure washing business. He actually owns a van. I think he was stopped in the van that he uses for work. I think that was impounded, so he may have some trouble with that. That was his primary concern when we were discussing his situation, was him getting back to work, him trying to get his van. But I know there are several warrants here, but like you said, Judge, it's really a traffic situation in which he aggravated some people, and so.
What's the total bond that's currently set?
Oh gosh.
Is $5,000 total. Each one of the traffic offenses appear to have $500 bond. The marijuana offense has a $1,500 bond, and
Oh,
the
no.
insurance
Okay.
has the $1,000.
Yeah, let's give him a $1,000 bond on the criminal trespass, and that's it. OR on everything else.
Your Honor, it'd probably be okay if I put that all in one. Is that okay if I put that all in one order?
Yeah,
together?
please do.
Okay.
Yeah. Yeah, we,
Do
yeah,
you
all
want
of that on
do you
one.
want to OR on the obstruction of officer and the simple battery as well?
Yeah.
Okay.
Got it. Thank you, Judge.
Let's see. Obstruction.
And I'll just leave the same conditions of bond on the criminal trespass. That way it'll match up with the first offense.
All right, and the next one is, let's see. Mr. Taylor, did you have announcements?
Not an announcement, but there's something mysterious. Miss Garcia was supposed to have a felony probation revocation this morning, but the jail says she was never brought up, or they told her that she wasn't needed for that this morning. I haven't heard from her public defender or anyone as to why that might have been, but
Whose
it affects her.
calendar is she on?
She was on Judge. Yeah.
Judge Mack.
Judge Mack.
Maybe they were waiting to see what we did here, perhaps.
That's possible. That is possible. It depends. It's up to you. If you want to go forward with her case today, then we can go ahead and you can pass on to the public defender that you would request that whatever she gets upstairs, if anything, it runs concurrent, but it's up to you.
Okay.
Because sometimes they do look at what happens with us on the misdemeanors before they'll make a decision on the VOP, the felony VOP. Probably what happened with us, whatever triggered our VOP triggered theirs.
Okay. I'll need to go back to the jail then.
Okay. Just go into breakout room number 1. All right. Go ahead, Mr. Moore.
No, I was going to advise Mr. Taylor. I was going to chat him directly.
All right, and Curtis Williams is a battery case.
Yeah, and I just realized when he went into the breakout room.
Yeah, he was in the chat.
I was going to modify the recommendation so it make more sense considering her circumstances. Okay.
I could just run in there and tell it to them if you want. Or
Yeah, she has a shoplifting. I was just gonna do. She's May 19th. I was gonna do 12 12 months to serve, 30 days balance suspended on no new violation. She's already on probation in Superior Court. So I don't see the point of putting her on misdemeanor probation, just to 30 days and be done with it.
I got you. Thank you. Actually, I'll just test it real quick.
All right, Mr. Brooks, we ready?
Yes.
Curtis Williams?
Yes, ma'am. Curtis Williams, we are ready.
He's before the court on 2022 CW 52509 for battery. And it looks like he's been in jail since June 21st of 2022.
Yes, ma'am, that is my understanding as well, as far as the timeline goes.
All right. I'm just going through his GCIC, Your Honor. In just one moment.
That's fine.
If you'd like, I'll go ahead, Your Honor.
Go ahead.
So, Mr. Williams, timeline given by the court is correct. So getting close to 90 days in custody on this battery. My understanding is that he has a great number of children for whom he cares. He's got, I believe, 11 kids total. I believe between him and his significant other, my understanding is there are 5 children in the household and that she is pregnant with one on the way, soon to get here. Primary reason I bring that to the court's attention, number one, is family ties to the community. He's got a lot invested here. Number two, he is the primary provider for the family. He works construction. He's actually pretty specialized doing metal roofing. Works with world-class construction is the company. He's got several other family members that are here, brother, sister, mom, grandma. I think he has had some recent criminal history that he did serve some time on. But I believe that was in Douglas County, I think.
Okay, in this case, Mr. Moore, it is going to be kind of important to me as who the alleged victim is, because with 11 kids, one on the way, things can get volatile. And if the significant other is one of the alleged victim or the alleged victim, then there's an issue that I'm going to have with that.
Of course, Your Honor. And I believe that it is the same person. I believe that it is within the household that's alleged. To that point, Your Honor, I did discuss with them. It's very likely that if the court is inclined to grant some sort of relief, possibly a secure judicial release, that the court would want the confidence that you're not going to have contact and that you're able to not have contact during the pendency of this case. To which she answered in the affirmative that that would be possible for them, but it is the same person. But
he got 11 kids and a new baby on the way. Even if he doesn't want to have contact, I'm sure she would. Dynamics being what they are,
I'm sure
this is a tough one. I mean,
right.
Like I said, it is pretrial detention. Mr. Brooks, let me hear from you.
Mr. Williams, the alleged victim is a lady named Rachel Cooley. It's unclear on the relationship to Mr. Williams, other than they did live in the same household.
Does the bond say, I mean, does the
It-
warrant
it
say
says-
that they're
and it does-
parents of the?
And no, just lived in the same, and you know, it does say in a relationship. And so he's Rachel Cooley, presumably is the mother of the children. Presumably, I don't.
That should have been in the warrant.
But it does say in a relationship and lived in the same household. He does have a history. He is a convicted felon, and it appears that there was a probation violation warrant filed March the 11th of 2022 out of Douglas County. That may still be pending. I'm not clear.
Was
but
that for a misdemeanor of a violent nature or for a felony of a violent nature?
the incident prior is from 2019 out of Douglas County Superior Court. So it's possession of a firearm by a convicted felon. The challenge here, I think, is also that in this case, the magistrate court issued a no bond, although he's entitled to a bond on misdemeanor offenses. And so,
Well, generally, but there are conditions upon which you can no bond someone who is has a misdemeanor.
Yeah.
I mean, if they have a probation or parole, felony probation or parole, or if they have a misdemeanor, a previous misdemeanor of a violent nature, I think you can no bond them. I used to know the statute by heart.
And I think that's what they were looking at based on the probation violation warrant and his prior history. We would request, if the court is to incline to grant him any relief, that it'll be a bond as opposed to an OR bond. That'll be a bond, and that conditions remain in place. He's to have no contact with Rachel Cooley. He's not to return to the residential address of 571 Trammell Road, apartment 12C, Morrow, Georgia 30260. The status of that probation violation is unclear out of Douglas County, but that still may be a thing that would detain him.
Mr. Moore, you had a question?
Yes, sorry to interrupt.
No problem.
I was just, I had him down, I was looking at all of this information, and I believe he confirmed that I think he's got a $10,000 bond currently. We are talking about Curtis Williams, right?
Yeah.
Mm-hmm.
Battery family, the information, I just get this from the inmate search.
He has a $10,000 bond?
That is what I see for them. $10,000 bond on the battery family violence charge.
When was that granted? Because the warrant I'm looking at is signed by Judge George. It has no bond on it.
So intake date, let me look at his app and so yeah, I see the same thing you have on his jail application, that battery family violence, no amount set on the same warrant, I assume, same time. That's weird.
And Your Honor, to be clear, I did looking at his GCIC, it does appear that Douglasville matter is still outstanding. It's showing as a wanted, and so I think there may be a detainer on him based on that. And it is based on the possession of a firearm by a felon.
Mr. Brooks?
Yes.
Do you have a full incident report for Miss Vanessa Garcia's case? Like I see like a front page, but there's no report. I see an accusation, a cover page, and a recommendation, but no narrative.
Okay, so the 1710-1, I'm sorry, 1710-1-3, subsection 3B says a parolee or probationer charged with a misdemeanor or misdemeanor involving physical injury or an attempt to commit physical injury or terroristic threats, or with a new felony, shall not be entitled to bond pending a hearing on the revocation of his or her parole or probation, except by order of a judge of the superior state or magistrate court wherein the alleged new offense occurred after a hearing and upon determination of the superior state or magistrate court that the parolee or probationer does not constitute a threat to the community, provided, however, that this subparagraph does not authorize state or magistrate court judges to grant bail for a person charged with any of the offenses listed in 1761, which is the 7 deadlies, or as they used to call them. So they can withhold bond until such time as a hearing is held on the existing matter, which I guess is the one out of Douglas County. But they did grant him a $10,000 bond.
I have it on the jail app initially. I have it listed as no bond, and then I looked him up in the jail, 2 weeks ago or whenever, and looked him up today, and it's on the internet, which however reliable that is, it has 10,000.
Oh, well. Mr. Brooks, any thoughts? He hasn't had a hearing, not a substantive hearing, regarding the previous open probation issue.
The state's request would be that no bond remain in place. Additionally, with regards to Ms. Cooley, because the case technically has not reached our office, we haven't even had contact with Ms. Cooley, the advisor of this hearing.
Yeah. I hate to say this, but he may have to sit for a minute, because based on this, the language is not may, it's shall. And I don't have enough information for me to be comfortable setting a bond where he's out, and he definitely wouldn't have contact with the previous probation regarding a gun gives me some concern.
I understand, Your Honor.
Okay.
Would the court be willing to attempt to try to order the case up in some fashion? I don't know, for whatever it's worth. Yeah.
Well, yeah, you can prepare. Let's see how much my word means down in magistrate court. So you can prepare a bond ordering that the case be bound up immediately, instanter. I like that word, instanter.
All right. I will, Your Honor. Thank you.
Mm-hmm. With all documents pertaining thereto transmitted with the case to the clerk of state court.
Got it. Thank you, Your Honor.
All right, and make sure you copy Jackie Wheels on it, because she's the clerk of magistrate court also.
Got it.
All right. What is next? Deontay Hernandez.
Or if I could just pull up his information.
Yeah, I can expedite as well. Speaking to the case, if the court would like.
Go ahead.
To the original warrant request, the state had no objection to the ORs being granted. However, Mr. Hernandez received a additional charges while in the jail that have been bound over to Superior Court.
Ooh,
And so he's going to be detained nonetheless.
okay, I don't know that this one is so much about the detention, but about moving the case, because he's been in jail since May 14th. So I get that there are new felony cases, but I think that this case persisting in magistrate court for this amount of time may delay what happens with him with respect to the felonies. And these charges that he would be before this court on are notwithstanding whatever happened in the jail. These are some relatively minor charges. And these are the type of charges that indicate either a mental health issue or a substance abuse issue, something for which, you know, alternative thinking outside the box might be necessary. Mr. Moore, pull this one up too. Do an order for this one to be bound up.
I will. And Your Honor, just the broad part, yes, I see what Mr. Brooks sees as well. As far
Yeah,
as-
I don't need to know all about that because he's not leaving the jail one way or the other until it comes up to me. I mean, then it becomes relevant to me. But these charges and where he is now, the case should properly be before us. So at least we can make a determination and, you know, then it can move on and on its course with respect to the felonies.
And the one that we're discussing, I believe that they have it listed as a battery.
In the jail?
Yeah, is that right?
That's correct. That's correct. If we could go into a breakout detail.
Yeah, no problem. So I'll put us in breakout room number 3. 1 second. So we've talked about Hernandez, and next is Crystal French. Why is that name familiar? She's been before me before.
Her last incident would have been in, January. She had a probation violation in January of 2022.
And that was mine.
I believe so.
See, it doesn't, my memory is amazing.
I believe so. But the state has no objection to an OR being ordered on her. She's been in custody since March of this year.
Oh my gosh. Yeah. OR.
Appreciate that very much. And as far as the wording of the order, same terms.
Oh yeah.
Bond conditions remain.
Yeah. Whatever the bond conditions were below, and no going back to incident location if that's not on there.
Got it. Thank you.
This presiding judge thing is kind of cool. So we're not doing Natalie or Nellis. We were waiting for a family member. Is that what's going on?
Well, I was expecting her to show up on Zoom. She did not. I was going to try to have a conversation with her. I spoke with Mr. Ornelas previously, but
And we did receive it in yesterday, and so it's going to be accused. If not today, then certainly tomorrow. It's in line to be accused today, though.
Okay.
There you go.
All righty. Well, we have done a good work here. Thank you all. Thank you. I just have to say this. In a lot of places, it's very contentious between the state and the defense. And I think that is not something that works well for anybody. Nobody benefits from that, because the whole point is to seek justice. And so I really do appreciate the way y'all work together on things. And I don't have to order, I just have to suggest or ask. So I appreciate that. Just want y'all to know.
Well, thank you, Ron.
Thank you.
So, all right, Mr. Taylor, what you got for me?
The report we received for Miss Vanessa Garcia is still just a cover sheet. I don't know if I need a conference with Mr. Brooks or.
Sorry to interrupt you, Wes. Is that the only case remaining that you needed the conference or kind of figure out?
I also need to talk to Harris again.
You need to talk to Derek Harris?
Yes.
Okay.
If we could, maybe I could just go back with Mr. Taylor. I don't know if Mr. Kamani has any more. I need to check on Mr. Lawson anyway. Kind of check in with him until I'm somewhat confident in where we're at. And then maybe I can help get all that straightened out too.
Okay, sounds good. So the jail is still in the breakout room. Mr. Kamani and Mr. Taylor are still assigned to the breakout room. And Mr. Moore, I'm going to put you in breakout room number 1 too.
Thank you.
All righty. Thank
Your
you.
Honor, I have announcements on my cases.
All right, Mr. Kamani, go ahead.
So I'm handling from hold. So that is stipulate and agree.
Okay.
Jaima King is a no-lo to count 2. Count 1 is a no pros. Moreno is a guilty plea to count 1.
Okay.
Snyder is a stipulate and agree. And to the technicals only. And Williams is a guilty plea as well and wants to use the first offender.
All right. All right. As soon as the jail comes back, we'll go ahead and clear all of those. Thank you.
Thank you. Your Honor,
Yes,
can you put me in a breakout room with Mr. Brooks for a minute?
sure.
Thank you.
Mr. Brooks, and you can go into breakout room number 3. 1 second. Mr. Brooks, you're already in breakout room number 3. All right.
Your Honor, I'm back and I have an update for the court. I believe Mr. Taylor is finishing up with Mr. Harris. I believe he'll be back shortly.
Yes, Mr. Moore?
In speaking with Mr. Lawson, I had forgotten, I was able to meet with them and kind of talk about the situation. I would like to be briefly heard on his bond conditions, if I may, kind of give you a little additional information over and above, the obvious issues.
Okay.
Is Brooks around?
Mr. Brooks is in with Mr. Kamani, I think.
Oh, gotcha. Okay, sorry. I didn't
Yeah,
realize.
so as soon as they come out, we will.
Great, thank you. And then Mr. Taylor will be back shortly.
Okay.
Mr. Brooks, whenever you're ready, I did want to have a brief discussion about Mr. Lawson.
Lawson?
Yes, sir.
Okay, all right. You want to go into a breakout room?
What I was going to say, just with the judge, I don't think.
Okay, gotcha.
I think I know what's appropriate, but and probably won't be unsecured release, but we'll see shortly.
Okay, go ahead.
Hey, Judge, thank you.
My tablet is charging, so you're gonna have to go ahead and read to me what the particulars are for Mr. Lawson.
That's all right. Thank you, Your Honor. I'll be brief about Mr. Lawson. I did have a chance to meet with him. I have my notes, which currently charged public indecency. He was arrested on July 7th. He's been in custody since then. Similar to everybody else, getting no action from the magistrate court. Primary objective is to have his case move along. In speaking with him, he was able to speak with me. You know, he is definitely aware that he's in custody. His primary objective, he wants to put all this behind him. You know, he reports to me that he has a stable residence and reports to me that he has a job. I've not been able to verify either of those things. However, I'm fairly confident that he's not a flight risk in the sense that he's been around for some time and he's not going anywhere. I did notice previous history of trips to Georgia Regional, but I believe whatever occurred there, they ended up finding him competent, either restoring him, is likely what happened, to where he was able to resolve his cases. But I guess we would be requesting release given the amount of time he's been in custody. If the court is not inclined to do that, I would certainly be requesting to move his case along into state court so that we can figure out something to do with it. So thank you, Your Honor. Appreciate you hearing us on that.
Mr. Brooks?
Mr. Brooks, you're muted, by the way.
Oh, I thought I was muted.
Now I was making a solid argument. It's probably my best argument ever, too.
Those are always the ones. Go ahead, sir.
Now, I was saying that Mr. Lawson, he's been in custody since July of this year, but he is out on bond on other charges. He was out on bond on other charges when he received this charge. He has an open case in Judge Garrett for criminal trespass from 2021. According to jail intake, he is homeless. And so I do have concern that there will be nowhere to send future notices, nor will there be a way for him to return if he has no means or no place to go. And so because of these special circumstances with Mr. Lawson, I'm going to make an asserted effort to see if we can move this case on copies and try to directly accuse the case. Because I don't think if he's released, he was going to return.
All right, Mr. Moore?
Nothing further. Then.
He has about 39 cycles, Your Honor. But I'm going to today try to see if we get copies of whatever we can to try to get it directly accused. The charge is public indecency, and I feel like that's something that we can resolve. However, if he does have some mental health challenges, then we can file, or counsel can file the appropriate motions in front of state court.
Okay. So what's the likelihood of getting it up this week?
I can, it's very likely. When you say getting it up, let me say, I can move it up.
Accuse it.
Yeah, I can move everything on copies.
Okay.
I just don't like to do it.
I got you, because that's not the proper way to do it.
So the answer is it can happen. It will happen this week. Because again, I have a sincere concern that he's gone. And it wouldn't be his fault for not returning. He just wouldn't have a way to receive notices.
Would you like me to do an order, just like for the rest, to maybe try to facilitate them sending that stuff up? For what it's worth.
I'm sorry, were you asking me a question?
Either of you. if I know that part of the state's concern, the direct accusation, is not having the proper information, not the directly, warrant signed by the judge and whatnot. If we could maybe just do an order for him, just like we were contemplating doing for Hernandez and others, telling the magistrate court to send us the paperwork to maybe help facilitate Mr. Brooks' direct accusation.
Let me add this caveat too. He will be in Judge Garrett's division, and so Judge Garrett has jail calendars on Thursdays, and so even if I accused it today, he would not make it on that jail calendar. He would be on next week's jail calendar. But if I get it accused this week, he'll certainly make the calendar next week.
And in all candor to both the court and Mr. Brooks, it's probably unlikely that he'll be resolving his case for anything that's going to have been released from custody. Frankly, I want to move this case up there as quickly as possible, just so I can put it together with the other one for which I believe he is going to be evaluated.
Can the court, and you know what? I think they have the ability to do it. A state court judge can certainly order a evaluation right now, even though he's not received into state court. I believe you have that authority. I believe here.
I'm sorry. As y'all can see, I'm a little distracted. I was trying to compose an email regarding the situation. Okay, so for Mr. Lawson, what are we doing? What do you need me to do? That's what
I'm sorry, Joe.
I was going to say, the solicitor's office is going to get the case accused this week, but I believe counsel believes he may have some mental health challenges that might warrant a evaluation. But I feel like state court can even order us evaluation, even though it's not properly accused. I feel like you still have authority since you're sitting as presiding judge over this matter. I think you can order an evaluation even from this posture.
Okay.
I think.
That may be a good way to go. It may not even be necessary. I think on that previous case, I think he was actually waiting on a
eval from Judge Garrett.
Waiting on a bed, perhaps, actually. So I guess at this point, I would ask the court if you'd be willing to just sign an order similar to Hernandez or one of the other ones, just telling them to send the proper paperwork to the solicitor's office for that direct accusation, just to try to facilitate.
This will get directly accused this week. Regardless if they send what they send, we'll do it off the copies just to make certain it moves.
Works for me.
Your Honor, the freeze.
Come in. I'm sorry. Like I said, I was zoned out. I'm trying to finish this email. Okay, sorry about that. What was it you were asking me?
I think we've actually talked about it enough where we kind of agree on what we're going to.
You don't need me. See, look, there you go.
Really, Mr. Brooks is getting ready to directly accuse it. And frankly, I think that's probably best for the case. So
that works for me. Mr. Taylor, what you got for me?
Announcements, Your Honor. Ms. Garcia would like to enter a negotiated guilty plea. And Mr. Harris would like to enter a negotiated guilty plea.
All right. All right, I'm ready to move forward with the cases on the calendar.
Did we complete all the motions, Judge?
Okay, the only ones I think we didn't do were the ones that were either already in the pipeline to be directly accused, or maybe the one where we were waiting to talk to a family member. Mr. Moore, did you want to revisit Ornelas?
That was one of the ones that was actually directly accused anyway, or
Okay.
was very soon going to be.
right.
And so I can touch base with her and mom after we finish. So as far as I'm concerned, that was it on that calendar.
Okay, cool. Thanks.
Sounds good. All right. All right, so the jail deputy, could you bring up Garcia, please?
Garcia?
Yes, please.
Okay.
Sorry, career right there. Garcia. Garcia. That's the other one.
Ms. Raise your right hand, Ms. Garcia. Do you solemnly swear or affirm any testimony in this matter will be true?
Yes.
All right, so whatever the second device is, it needs to be muted. All right, so you're before the court on 2022 CR 00758 for theft by shoplifting. You're represented by Mr. Wesley Taylor. Mr. Taylor is on the Zoom with you. Mr. Taylor, you've indicated that your client wishes to enter a plea of guilty.
Yes, Your Honor.
By entering a plea of guilty to theft by shoplifting, Ms. Garcia, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, ma'am? All right. Will the jail unmute for a moment? May I have the jail unmute? All right. So, Ms. Garcia.
Yeah, I'm by myself. I'm sorry.
Okay, no problem. Thank you. Ms. Garcia, you've understood everything I've said? Okay. Ma'am? I can't hear you. Okay. All right.
Yes.
All right, ma'am. Mr. Brooks, recommendation and factual basis and recommendation, please.
Yes, ma'am. On May the 19th of 2020, officers with the Riverdale Police Department responded to Walmart in Riverdale here in Clayton County regarding shoplifting. Officer made contact with loss prevention officers, advised he observed two women conceal merchandise and pass all points of sale without paying for the merchandise. Upon being stopped, they did find merchandise and totaling $57.55 that was unpaid for. This occurred here in Clayton County. State's recommendation is 12 months to serve, 30 days. The balance has been suspended. This recommendation is being made in consideration of the fact that she is already on felony probation in Superior Court of Clayton County.
Okay, Mr. Taylor, anything on behalf of Ms. Garcia?
We would ask that she be given credit for the time since the most recent lockup, but nothing further as to the recommendation, Your Honor.
All right, Ms. Garcia, how old are you?
38.
So what you doing with your life?
I already graduated college and right now I am in jail.
Okay, so that's not a really good use of your college degree. Is this a substance abuse issue?
Sometimes I guess.
What's your substance of choice, ma'am?
Liquor, alcohol.
So, Ms. Garcia, I just have to tell you that you're too young to let this take over your life. You have the opportunity to get it back on track. You consider going to AA and getting into meetings. If you're offered help, I don't know what's going on with your felony case, but if you're offered the opportunity to get into a substance abuse program, take it, because you're going to spend the rest of your life bouncing back and forth from jail to jail. And is that really what you want to do?
No.
Do you have children?
Yes.
How old are your children?
12, 5, and 8.
So who's got your children?
My mother.
Okay, let me explain something about that. Your mother loves your children, but she don't want to have to raise them. She raised you. And the more you mess up, the more that burden is on her. And the more your children realize that you basically are not doing what you need to do to honor the contract that you made with them, because they didn't ask to come here. But once you brought them here, you're responsible for them. To give up your responsibility and walk away because you won't make the choices necessary to get yourself together, you're dishonoring that relationship that you have with you. And your mama is tired. She raised you. She probably raised some other kids. She's not wanting to raise your kids, especially babies.
I agree.
So get it together, Miss Garcia.
Okay, I will.
I mean, I'm serious, because your children deserve better. And if you got to make the hard choices to go to a program and get yourself together, make that choice for yourself and then make it for your children. And how old is your youngest?
5.
Don't have any more babies right now, Miss Garcia.
My kids are tired. Trust me, I'm not.
Okay. All right. All right, Ms. Garcia. So I'm going to accept your plea. I'll give you 12 months to serve 30 days. Balance will be suspended as long as you have no new violations of the laws of the state of Georgia. Also, ma'am, I'll give you credit since the date of lockup, which in your case may be credit for time served. Okay. All right. You can go back with the sheriff's office.
Thank you.
All right. Deputy, may I have Harris next?
Hold on 1 second.
Thank you.
Okay, you can go. I'm sorry, Ron, I had a call. What do you need?
Who you got next? I'm gonna make it easy for you, Deputy.
Okay, I just brought down I got Hernandez on here. I brought down who else got sent upstairs, and King.
You have King?
Yes.
All right, bring up King. I think you can send Hernandez back. That was just a motion and we didn't need Hernandez for it. Mr. King,
Yes, ma'am.
raise your right hand for me. You solemnly swear or affirm any testimony you give will be true.
I do.
All right, you can put your hand down. You're before the court on 2022 CR 04229 for Jama Vasar King. You're entering a plea of nolo to count 2 criminal trespass. Count 1 loitering or prowling will be dismissed. By entering this plea, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, Your Honor.
All right. Factual basis recommendation, please.
Yes, ma'am. On August the 25th of 2022, officers of Clayton County Police Department responded to 5165 Norman Boulevard, College Park, Georgia, regarding a suspicious person call. Neighbors of the property advised that 2 men were in the structure that was in the house that was vacant, and given that the owner had passed away. Officers made contact with the house, did observe a broken window in the back of the house, entered the house, and did find Mr. King and another in the house. There were posted signs of no trespass on the property and no public to be present at the property. This all occurred here in Clayton County. State's recommendation to the criminal trespass offense count 2 is 12 months to serve 30 days. The balance is to be suspended upon him staying away from the property. Again, the property address is 5165 Norman Boulevard.
All right. Anything on behalf of your client, Mr. Kamani?
Your Honor, he's been in custody since August 25th. Request you to give him credit from the date of lockup.
Yes. So, Mr. King, I'll accept your plea of nolo. Count 1 will be no pros, and I'll sentence you to 12 months to serve 30 days, credit for time served. Balance will be suspended as long as you do not go back to the incident location and as long as you have no new violations of the law. Do you understand this?
Yes, Your Honor.
All right, you can go back with the sheriff's office. Deputy, who do you have up next?
Your Honor,
Yes.
forgive my inattentiveness, but I just want to make certain that I heard the record correctly about Ms. Garcia.
Uh-huh.
She entered a guilty plea, correct?
That's what I have.
Okay. All right. I was just confirming my notes here.
Mm-hmm.
I got Mr. Guzman. But did we
Okay.
have that one? Guzman?
Okay, so Mr. Guzman can go back.
Yeah.
Who else do you have up?
I have Mr. Harris, he said. Harris, Derek.
Okay, we can do Harris. Mr. Harris, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down, sir. You're before the court on Derek Donnell Harris, 2022 CR 04227 for obstruction of an officer. You're represented by Mr. Taylor, who's here with you on the Zoom. Mr. Harris, by entering a plea of guilty to obstructing an officer, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right. Factual basis recommendation, please.
Yes, ma'am. On August 23rd, 2022, officers with Clayton County Police Department in conjunction with the U.S. Marshal Services were attempting to execute a warrant at 6370 Old Dixie Road, room 215 on the individual. Officers made contact with that room to clear the room. Officers told everyone in the room, well, officers announced themselves as police officers, advised open the door and do not move, freeze. Individuals in the room, one individual, Mr. Harris, did not obey the officer's command to not move and did go into the restroom. And ultimately, officers charged him with obstruction based on the instructions of the officers. The state's recommendation to the offense is 12 months to serve, 45 days. The balance is to be suspended upon no new violations of Georgia law. State's recommendation is being made in contemplation of the fact that Mr. Harris is wanted out of the state of Michigan on drug charges as well. He is on felony probation in Clayton County Superior Court for drug charges as well.
All right. Mr. Taylor?
We can just ask that Mr. Harris be given credit for the time of lockup since August 23rd.
All right. Mr. Harris?
Yes, ma'am.
You got a lot going on, sir. How old are you?
I'm 29 years old.
Mr. Harris, you don't want this all to go into your 40s. You really don't. There's a lot of life left for you. So don't tell me, I'm just saying, you got a lot of stuff that you got to handle in the coming months and years. And I'm hoping that this will all, the decks will be cleared, because you do not want to go into your 40s going in and out of jails. I'm just going to tell you that. That's not where you want to be. Okay. Do you have children?
Yes, ma'am. I got a 10-year-old daughter.
Okay. So let me just say to you, the man that you present is who your daughter will look for to be her life partner. And if you're not presenting a good person and a good man who's there by her side and making sure she grows up right, then she's going to look for that bad person. So you got to clean it up so that you make sure that you're there to raise her right so that she gets the best out of life. You understand? It's never too late to turn it around. Okay? I speak these words of encouragement. I don't know your situation. I just know what you're charged with. But I speak these words of encouragement because you still got time to turn it around, and you gotta be better for her. If not for yourself, you gotta be better for her. You understand? Okay, so I'm going to accept your plea. I'll send you to 12 months to serve 45 days. I'll give you credit since the date of lockup, and the balance will be suspended as long as you have no new violations of the laws of the state of Georgia. Okay.
Okay, so all I gotta do is how many more?
I'm not sure when you were arrested, so I'm going to give you credit since the date of arrest, and also understand that I can sentence you, but the sheriff's office determines how much time you actually spend on the sentence that I give you. So they may have a different calculation. Also, I'm not sure whether Michigan wishes to extradite you or whether you're going to directly go up and handle the issues in Superior Court. So those are all the things that are on the table. All I know is that at the end of the 45 days, this case will be done. Okay.
Yes, ma'am.
All right.
Everything.
All right, sir. You can go back with the sheriff's office. Thank you. All right, Deputy, who do you have up next?
I have a Williams or Marcus Dijon.
All right, I'll take him. All right. Raise your, are you Mr. Williams?
Yes,
Raise your right
ma'am.
hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, sir.
You can put your hand down, sir. You're before the court on 2022 CR 04238 for simple battery. Mr. Kamani, who is your attorney, who's with you on the Zoom, he has indicated that you wish to enter a plea of guilty under first offender statute. Now, I'm sure Mr. Kamani has explained to you what the responsibilities are for you for first offender. By entering this plea, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not, a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis and recommendation, please, Mr. Brooks.
Yes, ma'am. On August the 20th, 2022, officers with the Forest Park Police Department responded to Food Depot on Morrow Road when they got a call from a store manager who advised that he observed a Black female being assaulted by who the manager believed was a boyfriend. Officers did come to the store. They made contact with the couple, did identify Mr. Williams as the individual involved in the altercation with Ms. Sadrina Huff. Based on the investigation, officers did determine that Mr. Huff did grab and push Ms. Huff on the back of her neck to the ground. It's all occurred here within Clayton County. State's recommendation on the charge, given the facts and the history of Mr. Williams, is 12 months to serve, 60 days. The balance is to be probated. He's to have no contact with Miss Sadrina Huff. That's SONDRENNA Huff. He's to complete 40 hours of community service and pay a $300 fine.
Did you do family violence intervention?
I did not, Your Honor. He is charged with simple battery because the familial status was not known.
Okay. Mr. Kamani?
Nothing further, Your Honor.
Mr. Williams? Sir, no relationship has ever improved with somebody putting their hands on the other person. That is not the way to make sure that this is a love relationship or that it lasts forever. That's the quickest way to run somebody away from you. So just keep that in mind. I'm going to accept your plea of guilty under first offender statute. If you successfully complete the terms and conditions of the sentence, then this will not appear on your GCIC to negative effect. So, sir, I'm going to accept your plea of guilty. I'll sentence you to 12 months to serve 60 days credit since the date of lockup. The balance will be probated for you to take 40 hours of community service and pay a fine in the amount of $300. It's going to be $444 with the surcharges. And you're to have no contact with Sadrina Huff. Now, when I say no contact, this is what I mean. You can't call, text, talk to her directly in any way. You can't have your mama, your friend, your sisters, nobody. Don't have anybody threatening her on your behalf. No Facebook, no Instagram, no social media whatsoever. You're not to have any contact with her. And if you were to have contact with her, the remainder of your sentence, the balance of the 12-month sentence would be served in jail after a revocation of your probation. Also, you could be charged with misdemeanors or felonies as appropriate to the situation. Do you understand?
Yes, ma'am.
All right. If she contacts you, You can keep a record of it, but do not respond. Do you understand?
Okay, yeah, okay.
What's the problem? You got a question?
Because I was trying to tell the police officer because it's numerous reports of me trying to tell the police officer that I don't want her around me and all that, you know. And now that we got into it or whatever, that she just got a little push or something like that. I gotta do the time and I get all of this. But I've been told the police officer like some weeks, but way before that. They came to the house, my grandma's house numerous times.
How do you know her?
I was just driving and I decided to give me some rest and she came to my window, started talking from there.
All right. Mr. Williams, then make sure you don't have any contact with her. And if she has contact with you, you keep a record of it, okay?
Yes.
Yes, Mr. Brooks.
Your Honor, there is one more matter. He is not eligible for first offender.
Mr. Kamani?
He used first offender on aggravated assault charge in Fulton County in 2015.
Oh, okay.
Mr. Kamani, confirm whether he still wants to do the plea under a regular plea.
Mr. Williams, so you've already used your first offender before, so we cannot use it again. So do you still want to go ahead with your plea of guilty?
Will I still receive 60-day sentence?
Yeah, the sentence remains the same. But you cannot use your first offender because you've used it before.
So everything just, I guess, sir.
Yeah, you will get from
you get the same sentence, Mr. Williams. I'm not gonna change that.
Excuse me, Judge.
Yes, I'm listening.
I just want to say I apologize and I need mercy from the court because I've been going through some things and I needed her to help me. I thought she was gonna help me and I thought I would put my trust in her, but you know, now I see what really what really happened on the female side. So I just
okay.
need
So Mr. Williams, this sentence is merciful based on what is known about your possible record and the situation that occurred. You'll get the same 60 days. Do you wish to go forward with the plea?
Yes, ma'am.
All right. So the plea will be amended to I'll accept the guilty plea, but it's not under first offender. 12 months, 60 days, balance probated for 40 hours of community service and a fine of $300 and no contact with Sandrina Huff. Mr. Williams, I'm going to put you in a breakout room with Mrs. Thomas. Mrs. Thomas is our probation expert. And she's going to tell you what your responsibility is once you get out of jail. So you're going to have to do probation. If you mess up on probation, you're going to get arrested again. Do you understand?
Yes, ma'am.
All right. So once you finish speaking with Mrs. Thomas, then you can come back. Then you can go back with the sheriff's office. Deputy, before you go into breakout room number 6, the remaining cases that I have, and you can bring them up in any order. I'm not particular. Are Holt, Moreno, Snyder, Holt, Moreno, and Snyder. All right, so you can he can go into the breakout room with Mrs. Thomas when you're ready.
Okay, and Judge, the other 10 inmates, you don't have to see them?
No, sir, those they were up for motions consideration. We've had a discussion about those cases and the court is going to issue some orders regarding them, but I don't need to see them directly.
Okay, thank you, ma'am.
You're welcome.
I'm back from the breakout room, Your Honor.
All right, thank you. Deputy, this gentleman can go back and we'll get either, let me see, Holt, Snyder, or Moreno next.
Okay, thank you.
Okay, just let me know.
Mr. Holt here.
Yeah, answer for you too. I missed 2 court dates. Just miss my name, please.
Or she told me specifically to everyone go back.
Change the answer.
I can't by myself. Give me a second.
All right, Mr. Holt.
Yes, ma'am.
All right, 1 second, Mr. Holt. Let me pull up my, your petition on my calendar. Mr. Holt, raise your right hand for me. Do you solemnly swear or affirm any testimony that you give in this matter will be true?
Yes, ma'am.
All right, so Mr. Sartorius Darnell Holt, you're before the court on, you can put your hand down, I'm sorry. You're before the court on 2021 CR 07956. For battery, you were before this court for battery on the 9th day of November 2021. You were sentenced to 12 months probation. You have 3 months and 7 days remaining. Your probation was told because we did lose track of you. You failed to report on December 15th of 2021, January 15th, January 28th, April 15th, and April 22nd for an in-person hearing. On May 15th of 2022 and on May 26th as directed. You last reported on May 12th by phone of 2022. You failed to enroll in and participate in an anger management program. You failed to complete 40 hours of community service, and you're $400 in arrears. Mr. Kamani, tell me about Mr. Holton, this petition. You're muted, Mr. Muhammad.
Your Honor, he would like to stipulate and agree to the recommendations.
All right. And Mr. Austin, what is the Office of Probation recommending in this case?
Your Honor, the recommendation is 30 days to serve and close this case.
All right, Mr. Holt, where you been?
Miss Judge, I've been struggling with homelessness, and last time I put my phone because I had just got my phone, I had just got out, and I had got robbed for my phone, so I haven't been able to get no phone, and like right now, I supposed to go to the program to help me with like drug and alcohol and homelessness, and it's a detox program. I supposed to start a program this week. I got my mama talking to the lady now. Then I supposed to be going to a Potter program to help me out with my homeless. But first I'm going to that detox center to help me out with my alcohol problem and my homelessness. And because I do have a problem with alcohol.
Okay, you said you're going to the Potter's House program?
Yes, man. First, I'm going to the detox center first. I'm trying to do both. I'm going to the detox center first. I really need help. I need help with homelessness and alcoholism. I'm going to do that. I'm going to the Potter House on Gateway. But first, I got to go to the detox center. The counselor called. The name is Miss Cynthia Jones. She gonna help me out with my detox. And if that better than Gateway, I'm gonna stay there. Help me out with my alcohol problem, detox, and anger management. I probably started. But when I get back, my mom probably be setting up for me now. So when I get out, I go ahead and get started with help. I really need help with homelessness and alcoholism.
Mr. Holt, I'm glad that you realize that, sir, and I'm glad that you're taking the effort to get straight, okay? All right. So this is what I'm gonna do for you. I'm going to accept the stipulated agreement between the probation office and your attorney. I'm going to revoke 30 days. I'll give you credit since the date of lockup. And once you've served those 30 days, and you may already have served them, then your case will be closed, okay?
Ma'am.
All right, do well in your program, Mr. Holt.
Yes, ma'am.
All right, thank you. All right, Deputy, who's next?
Mr. Snyder.
Okay.
I go with my phone?
Yes, you can go, sir.
Can you look up Zachariah Williams? Zachariah Williams?
Oh, Mr. Williams can go back. His was a motion.
You can go back. Your Honor, he wants to.
Go ahead, ask me, sir. What's your name, first of all?
Zachariah Williams.
All right, Mr. Williams, what you need to know, sir?
I've been here for going on 3.5 months for my misdemeanor.
I got you, sir. Listen, your attorney has already talked to me about that, and we've already worked it out, okay?
Can I ask what date will I come back?
Mr. Moore, do you have, or Mr. Williams, what did we agree to?
Sorry, Your Honor, we're talking about Zachariah Williams.
Yes, sir.
Yes.
One moment, please, Your Honor. So on the criminal trespass case, bond will be set at $1,000. With regard to the series of traffic, all the ones on the later date, the court is releasing him on an unsecured judicial release.
Okay, so your bond's been greatly reduced, sir.
How much is the bond again?
$1,000.
Do I get time served for this? I don't have any money. I've been here since July the 22nd.
I know, I reduced the bond. You got a bunch of cases, you know that, right?
It's just misdemeanors and tickets.
Mm-hmm.
Mr. Williams, she's releasing you entirely on all that stuff with the ticket, and she's reduced your criminal trespass bond to $1,000.
All right. So when do I come back for court for the criminal trespass?
That's a good question. It'll probably take a while before that comes before the court. So you need to make sure your address is updated.
All right. So no court date yet?
No, sir.
But Mr. Williams, just so you know, technically your case is still in magistrate court. I am presiding as the state court judge, the presiding state court judge for this month. So I get to review motions for bond modification that are still in magistrate court. And yours was one of the ones that came up that was entitled to a significant reduction in bond based on what the state and Mr. Moore and I talked about. So I don't have the ability to just tell you when you're going to get a date because you're not even in state court yet. It's still in magistrate court. And so until they move it up, we're having difficulties getting these cases moved forward.
Yeah, my lawyer said y'all had misplaced me in the system.
I didn't. It's not even with me yet. Your lawyer's doing what he can to get it to our attention because this is the court where we can resolve your case finally, but it's not even here yet. But what I am doing is I'm contacting the judge in charge of magistrate court to see what we can do to get this case moved up. Okay.
Yeah, 'cause I had talked to the lawyer yesterday. He said I should be getting time served for being in here so long.
Well, if you were here, meaning if your case was under my jurisdiction to make that decision, that is a possibility, but it's not even before me yet. The only thing I could do was to talk about your bond and then to push for it to be moved to state court. I may not even be the judge that your case eventually ends up in front of. It is possibly another judge, but I have the ability right now to make a difference with respect to the bond.
So my bond, it was still $1,000.
Right.
I told the lawyer yesterday I couldn't afford the $1,000, so he just said I should do time served because I had no job.
Mr. Williams, let me go ahead and get this order taken care of, and then your attorney will discuss with you more about what's going on with your case.
All right.
Okay.
Have a good day.
All right, sir.
And Mr. Snyder. You can go back to
Mr. Austin, for some reason, when Ms. Chang is sending me stuff and she has a bunch of y'all on the list of people to receive the order, it's not like I'm not able to attach the order, but if I do the transmittal email myself, then I'm able to attach the order. So I just, I'm redoing them, but hopefully you all are receiving them.
Yes, Your Honor, I did receive the first one for Mr. Guzman.
Okay. All right. So that's what's taking it a little bit longer. I can't just hit reply. I gotta prepare a separate order and do it. And I'm not sure why that is, but all right. So Mr. Schneider is our next person. Is that correct?
Yes, ma'am.
Okay. Is this Mr. Schneider? All right, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, put your hand down. So you're before the court, DeMontavious, Richard Schneider, is that correct?
Yeah, yes, ma'am.
Okay, 1 second.
Take your call from man.
There we go. All right, so Mr. Snyder, oh, I'm sorry, it's Rashawn. Mr. Snyder, you're before the court on 2022 CR 01355, State of Georgia versus DeMontavious Rashawn Snyder. Mr. Snyder, you were before this court for reckless conduct on the 26th day of April 2022, and you were sentenced to 12 months on probation. You have 6 months and 2 days remaining on probation. Your sentence was not told. You are before this court for violation of criminal law. You've been charged with the new offense of possession of a weapon during the commission of a crime, assault, aggravated assault, and malice murder on August 28th of 2022. You failed to attend a gun safety course as you were directed, and you're $100 in arrears. Mr. Austin, what's the recommendation of the state of the probation office?
It was, but the technicals only was 60 days to serve and close the case out. At this time, Mr. Snyder has not been scheduled on or arraigned on the new charges at this time, I believe, and therefore we was just gonna move forward on the technicals.
Mr. Snyder, I remember you, and what I do with all of these gun cases, especially for young people, is I fuss at y'all and try and point out to you how if you just running around with a gun, how likely it is for someone to get hurt or killed because guns are not toys. And if you are using them in a reckless manner, something's gonna happen. I know I said that because I say it every time. I could go back and look at the hearing that we had on that date, but I'm not even gonna bother because I'd say it every time. And my understanding is from these charges that you totally ignored everything I said about having a weapon, the of a weapon, care you take when you have a weapon in your possession and how to safeguard a weapon. You totally ignored all of that. And there's don't say nothing. Don't say nothing. The consequences are something that you're going to have to live with for the rest of your life. Nothing I can sentence you to that's going to make a difference. Because had you listened to me, we wouldn't be having this conversation. And since since you hard-headed and you're not going to listen, then now your road gets a lot harder. Everybody want to be a gangster. I just don't understand it. How old are you, sir?
21.
Okay. You know where you headed, right?
I mean,
I mean, you headed upstairs. Now, I don't know what's going to happen when you go upstairs, but I'm gonna tell you right now, in court, we have the ability to talk to you, to be compassionate with you, to tell you we hope things change. Let's talk about how we can change, how you can change your mindset to be better. Upstairs, they don't have the time to do all that. They got mandatory minimums in prison, not jail. So that's all I can say to you, sir. Mr. Kamani, you and Mr. Austin have determined that 60 days is a sufficient time for this particular case and a stipulation to the technicals.
So that's right, Your Honor.
Right.
Ooh, Lord. All right, so Mr. Snyder, it is my policy that when a person has new charges, I will accept a stipulation to the technical only, because that allows you to maintain your innocence with respect to other charges that you may be facing. And so that being the case, you are stipulating that you have failed to meet the technical terms of the probation order that I had sentenced you to in April. And your case will proceed upstairs, and you will have the right to maintain your innocence. Okay. I'm going to accept the recommendation and the agreement of the attorneys. I'll sentence you to 60 days. After the service of 60 days, this case will be closed. Do you understand, sir?
Yes, ma'am.
Mr. Kamani, do you have any questions from on behalf of Mr. Snyder?
Nothing further, Your Honor.
All right, one moment. The court is going to decline to give you credit since lockup. All right, sir, that order is going to be sent to all parties involved. You can go back with the sheriffs.
Thank you, Your Honor. Can I ask one question?
Okay. All right. So the last one is Moreno.
Moreno? Okay, hold on.
Mr. Moreno, raise your right hand for me. Do you solemnly swear or?
Your Honor, that's not Moreno.
Oh, who's this? Miss Deputy, who's this gentleman? Mr. Kamani says this isn't Mr. Moreno. Okay. All right. So for housekeeping purposes, Deputy, this is the last person we have who we need to see. All of the other parties, their cases have been discussed and taken care of.
Thank you, Judge.
All right. Thank you. Miss Moreno, this is the you're before the court on Jamie Lee Moreno, 2022 C. Yes. 2022 CR 04233 for obstructing an officer. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. Your attorney, Mr. Kamani, says that you are entering a plea of guilty. By doing so, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, ma'am. On August the 22nd of 2022, officers with the Forest Park Police Department initiated a traffic stop on a vehicle that was officers attempted to initiate traffic stop, but the driver of the vehicle did flee in the vehicle and from the vehicle. Inside of the vehicle were two passengers. Miss Jamie Moreno was one of them. Officers did give instructions to stop running, to which she did fail to stop running, and then ultimately when they were able to apprehend her, she did resist lawful arrest. During the course of the investigation of the stolen vehicles, officers did learn that Miss Moreno was wanted by the U.S. Marshal Services out of New Mexico for a federal felony probation violation. This all occurred here within Clayton County. State's recommendation is 12 months to serve 30 days and suspended upon her release to federal custody.
I'm sorry, that last part faded away. Balance suspended for release to federal custody. Is that what I got?
That's correct, yeah.
All right. Mr. Kamani?
Yes, Your Honor. She's been in custody since August 22nd, and I request you to give a credit from the date of lockup.
All right. Ms. Moreno, I'm going to accept your plea of guilty. I'll sentence you to 12 months to serve 30 days. Balance will be suspended for you to enter the custody of the federal marshals or whoever they designate. All right. So you can go back with the sheriff's office at this time, and I will give you credit since the date of lockup.
Thank you, ma'am.
Thank you.
You're welcome.
Thank you, Your Honor.
All right, ladies and gentlemen, I think that is all we have for this morning. I'll be signing. I'm in the office, so if you need me, I'm here, and I'm signing any stuff that you sent to me.
Thanks, Judge. I'm working on it right now, so hopefully I'll have them over to you here in just a little bit.
Okay. All right, Mr. Austin, I see that, and I'm looking for it, but while I've been online, I just been doing the petitions, and if she sent something, I'll sign it as I'm signing all the other stuff.
Okay. No worries.
All right. Thank you.
Thank you.
Thank you.
All right. Bye-bye.